97.3 Citi FM. Relevant radio, always.
It's legal research.
Mr. Amekudzi, you've not answered my question. My question was that, in your view, what exactly was constitutionally offensive at the hearing of this particular matter, the Supreme Court matter having to do with the 2012 election, that provoked you to go to court, as you say, dutifully, to seek to protect the presidency?
Thank you. We all know that every provision inserted into the Constitution has a legislative history or a legislative intent. They are not just inserted into it for inserting sake. Take for granted that last Wednesday was the 46th sitting day of the court. Now, granted that the president of Ghana, who has been given the mandate to administer the country, to do the people's business, the people's work, should leave his office every 9 o'clock and to be in the court until the court closes 4:30 p.m. When will the president come back to office to do the people's work? I leave it to not only you here, but to every Ghanaian and all our friends all over the world.
But the flaw in that suggestion is that, as we speak, the president's matter is before a Supreme Court of Ghana, and that court is hearing the matter, yet the business of running the state is still continuing. There's no disruption whatsoever to the business of administering the state from the Flagstaff House.
If you listen every day, when I went for the first order, the ruling of the case affair, you will see the record shows that the first respondent, that's the president, absent. And the framers of the Constitution never contemplated that our sitting president, while in office, should be made to become a litigant. That is why Article 57, clauses 4, 5, 6, clearly provided to protect the president.
That statement you just made is itself constitutionally offensive, because if you look at the Constitution, Article 64 thereabout, there is provision made for the president's legitimacy or the election of the president to be challenged to the extent that a citizen of the land believes that the right set of things were not done to make him president.
Well, I'm aware that this case is still pending before the Supreme Court. I do not want to preempt anything, but I also know under Chapter 5, Article 21 of our Constitution, of my freedom, my right of freedom of speech, and my freedom to exercise academic freedom. And we are doing this exercise under this context. And I want it to be seen under this context, that as a citizen of Ghana, it behoves on all those who have the knowledge to educate the people, so that when the Supreme Court comes out with its final ruling, people will understand it. That Article 64 clearly provides that election of a president may be challenged. May. But when you come to Article 57, they use the legal language when the interpretation made it mandatory. Mandatory is compulsory. That you cannot send the president to court.
But do you know the problem with your interpretation of the provisions of the Constitution? I'm not a lawyer, but what is clear from that provision you just cited under Article 64 is that the framers of the Constitution are aware that there will come a time when people will feel aggrieved, or people will feel that the election of the president has problems. Therefore, they would want to seek proper remedy at a court of competent jurisdiction. That was why the framers of the Constitution used the word may. I suggest that to you.
Thank you. in my response to what you suggested, if you go to Article 57, clauses 4, 5, and 6, you see clearly that clause 4 provide that any other under this constitution or any other law, Article 57 has taken precedence over it.
I don't understand the argument you're making, sir.
I said, when you see, if you read,
which of the provisions are you talking about?
Article 57, clause 4.
Okay. Of the Constitution?
Clause 4.
Yeah. Has done what?
Clearly provides that any provisions under this Constitution or any other law, this has taken precedence over them all, including Article 64. That is why I made the argument, other provision or any other law to it. That might yield, that other provision must yield to this clause.
Do you realize that in performing his functions, the president must be seen, not only seen, but must be deemed to have acted or to have become president through the right channels laid down by the Constitution of our Republic?
Listen, there is a determination for the Supreme Court.
Yeah, we are not dealing with the merits of the matter. Yeah, we're dealing with the academic side of it.
All that I am telling you here and telling all Ghanaians, good people of Ghana, and our good people who are our friends throughout the world, is that the president has his own mandate.
Given by the Constitution.
President, it's not the duty of president to conduct elections and to declare elections. The duty is what? The Electoral Commission of Ghana.
Yes.
So if anybody is talking about election, it is not the president. It should be easy. The appropriate party that the petitioners should have brought this action should be easy.
Do you realize that if the president is left out of this litigation, what it means is that we could have problems enforcing whatever declaration would have been made at the end of the day by the Supreme Court?
Thank you. That I don't want to go there. You mentioned a declaration. That's a legal issue also. I leave it to the court. Whether or not a declaratory judgment is the same as a specific performance order judgment.
Which means what?
A declaration is to declare an act a valid or not valid, constitutional or not constitutional, period. That's all.
Yes.
But see, what I found very difficult to understand in this matter is that the second petitioner, Dr. Bawumia, told the court and the world, and it becomes a proverbial household word, you and I were not there. Listen, meaning that all these purported allegations they are talking about never occurred at the actual polling stations. But it's what? Based upon what? The pinch check. So the issue is, whether or not those errors, if there were any at all, constitute malpractice in the real sense of malpractice. Whether they were only hypothetical, doctrinaire, being postulated to be tested.
Are you suggesting that because Dr. Bawumia was not there in the field, he did not have the locus to be giving credible evidence before the Supreme Court on matters he did not have personal knowledge of? Is that what you're suggesting?
Listen, in the law of evidence,
yeah,
hearsay evidence is inadmissible before our law court.
Who told you that?
As a lawyer, I know.
Well, my reading of section 117 and 118 of the evidence decree gives me the impression that hearsay evidence is admissible under some circumstances.
It's never admissible.
Have you read the provision, Lee?
Look, hearsay.
Yes.
Under the circumstances. What is the exceptions you've seen over there? Hearsay evidence is hearsay. You must have the foreknowledge. And he has no foreknowledge of those malpractices occurring. And then their agents never also made any official report to them. So it was only a gesticulation of an assumption of hypothetical doctrinaire. They sent to court to go and test. Well, whether or not, the legal issue here is that whether or not the court will accept such hypothetical doctrinaire, hypothetical tests. But I know our court rejected this postulation in the famous case of Salah versus Attorney General. This issue happened during the Progress Party, which is the same offshoot of the New Patriotic Party, NPP. That was when the late His Excellency Right Honorable Professor Abrefa Kofi Bushi was the Prime Minister. And His Excellency, the late Ceremonial President Edward Akufo-Addo, incidentally being the father of Honorable Nana Akufo-Addo, the first petition. When maybe you all heard those or you read it.
That what?
About the Apollo 568 case in Ghana, when 568 workers were dismissed.
You would say that because they threw out your application, you know, on basis of law, they were wrong in law.
No. The court never. What the court said at the review by the 11 panel judge unanimously, that the issues are brought before them was not frivolous. They've taken the substance of it. But I myself lack the locus standing because I'm not a party in it. So, and more so, surprisingly, counsel for the president objected to it. Counsel for NDC also objected to, and that is what I can never understand. If they had supported it, that
because the application was unmeritorious, it had no basis in law, and it was wrong ab initio.
The court never made such a ruling. The court said it was not frivolous. It was what? They've taken the substance of it. You see, when you go to court, we all know, every lawyer knows they have a litigation strategy to manage litigation. Now, if at that time you have not canvassed the position of the law, and another friend of the court canvassed it, I was expecting them to support it. If they had supported me, the court would have made a ruling. But now we are waiting to see whether in their written addresses, whether they capture this position.
Thank you very much, Mr. Amekudzi, a lawyer who went to court seeking to argue that President John Dramani Mahama could not have been sued under the Constitution of Ghana, depending on where you look at it, from where you are standing, per the provisions of Article 57 thereabout of the Constitution. But the Supreme Court held a different view, and as we speak, the matter of President John Mahama's election or otherwise, legitimacy or otherwise of it, is to be determined by the Supreme Court.
97.3 Citi FM. Relevant radio, always.